Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy. The dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
Is the next search on February 28, 2020? 7:44 p.m. How, does the FBI find people? The people's misspelled P-E-O-O-P-L-E.
I object.
Did the defendant find out how the FBI finds people in this case? Oh, she found out.
What more do we need to see?
All right, welcome. Welcome back to the Court of Public Opinion. I am the Recovery Addict. It seems like we were just here. It seems like we were just here. Oh my goodness, what are we in for? What are we in for? We have the brand new letter that just dropped from Sarah Boone. 58 pages of hand-delivered letter to the judge, and we have our copy now. I've got it in front of me. I have not even opened. It's still sealed. It's still in the original manila envelope as far as I'm concerned. I've peeked at the front cover. That's it. So I will be looking at this the first time with all of y'all. I have to say welcome to Ivan Victor, first in chat this afternoon. Ivan, thank you. I realize you're a busy man with the lumber mill and all, plus you're a YouTuber yourself. You've also got some other business ventures going on, some of which we can mention, others which we'll just keep quiet. But in addition to all that, because you're first in chat, we're going to send it to you to internet ownership. You're responsible for everything IP-related worldwide. Not that you get to benefit hugely from that, really. You just have to do the work so that everyone else can. But you know the drill. Appreciate that, my friend. Good to have you first in chat. We are excited to bring this letter to you today. In doing so, before I go into this letter, let me just reiterate that with every letter we read from Sarah Boone, two things happen. First of all, I become more convinced that she is delusional about the state of her case and her future. And second, I am more concerned with the delays that have brought us to this point in her case, that she is still sitting locked up without having had her day in court. Now, I realize some of these delays, you might look at her and say they're her fault. Some of them might be outside of her control. Either way, it's starting to become a problem. And the complaints she's raising are legitimate in some cases. So this is something I feel strongly about. And with every letter, it just is more clear to me that she does deserve a chance to have her day in court. It might go down in flames. It might be terrible for her. But to have her held in custody without ever appearing in court, especially where she says that she never waived her right to a speedy trial, we have issues. Okay, so let me lay that on the table first. Quick shout out to a couple people who just hit membership milestones. Piero Adam Nusky, Sarah Boone's magnum opus. Okay. Yes. Breezy member for 14 months. By the way, Adam, 16 months. Congratulations. Breezy member for 14 months says, I love it here. We love that you're here, Breezy. Thank you very much. Jen Pookie, member for 12 months here. Oh, got an orange courthouse by your name now. That's wonderful, Jen. Says a whole 12 months and a Sarah Boone letter. Yay. That's like icing on the cake. Emily Arenas. Emily Arens. Sorry, I looked at that wrong. That's a member for 3 months. Says, thanks to whoever gifted me again. You're all awesome. Also, happy for a Karen Reed trial reprieve. When, if any time, will it end? What if any time will it end? It's not going to happen, according to Lally. His closing words will be, what if any? And then he'll sit down. I think that's how it's going to happen. It's Friday. We have a letter. Did I see a text about the mystery oil for your lawnmower? I saw that. There's like some magic oil I can put in it that will fix everything. Not sure if I'm going to buy it, honestly, because I buy a preset oil filter that's pre-filled with oil. It's a quick oil change. You change the filter and it has all the oil in it. It's the most amazing thing. I bought this tractor for that very reason. So it's really, really unique. Anyway, it takes 90 seconds to change the oil on my tractor, which I have done, by the way, once in 5 years. Mike W. says, hubby is watching the Euros on the TV, and I'm here for Sarah Boone news with a bottle of wine and the read-along. Love it. Thanks for the 9 months, Mike W. Kimby, woohoo! Love Recovery Addict. Thank you, Kimby. And 12 months for you as well. Congratulations. The whole year mark. Silky Mom, member for 7 months. She really does need her day in court. I agree. 100%. I will stand up and cheer and fight for that if I can at any way. And hopefully us reading this letter, although it's insightful into her case, and we sometimes have a little chuckle at the fact that her perception and reality might be very different than ours. She deserves her day in court. She deserves representation. She deserves her day in court. I think there are some things she could do that could have sped that up. But even so, that's great. Todd Hudat Clement says, a member for 6 months. Yellow Courthouse, love it, says, thanks for all you do. Watch out for hurricanes. They happen. Thank you. Michelle Phillips in North Carolina, member for 12 months as well, says, yay, thanks again, Red Pen. It looks like Red Pen was the gifter for you, Michelle Phillips. That's wonderful. Red Pen's amazing. A lot of people can thank Red Pen for their memberships. All right, let's kick this off. We're going to read the letter. Let me bring it to you on screen so you can see what I am talking about and what we're going to be going over here now. And let's see. Here we go. It is hand delivered. It's also handwritten. Sarah Boone, dated June 7th, 2024. Obviously, that was 2 weeks ago. It does take a while for the letters to get in. Shells comes in with a 17-month membership mark. Says, hi, can't wait to listen. Thank you very much, Shells. Appreciate it. Love the Orange Courthouse. Honorable Judge Michael Kranick with his address. That's a business address, by the way. From Sarah Boone, we have Sarah Boone, Smart Communications. Has she started a company? Sarah Boone, Smart Communications, Orange County Department of Corrections. Or is she just being like a smart aleck? Did she start a company in jail? Because she has a regular correspondence and a legal correspondence, which has different emails. So Smart Communications is P.O. Box 9101, Seminole, Florida. And then she's got P.O. Box, regular legal correspondence goes to P.O. Box 4970. Huh. 2 different cities. Total number of pages, 58. Filed in open court, dated 6/20/24. I guess it was just filed yesterday, so it took a while to get scanned in. Honorable Judge Kranick, ongoing 5 years. Why can't I use my constitutional rights? Am I the only one who cares about the ongoing violations of? Have a bond? Have all my medical records? Have all my digital evidence and discovery? Have all my paperwork, notes, letters, pictures, everything of mine returned by former attorneys? Speak to my investigator? Have a complete download of my phone? Have any of my witness lists? Give any insight, understanding, clarification, truths about my case, especially to my attorney? Be listened to by anyone, especially my attorney? Be respected for who I am, truly, especially by my attorney, and not be disrespected for the Is it mutated? Something tated. I think it's mutated malicious. Yeah, that's an M. The M looks like an N. So mutated malicious murderer, all of the world has falsely, incorrectly created and believes me to be. That's a double negative. I don't think she intended falsely, incorrectly to be there. Be treated fairly, lawfully, and be protected by the justice system. Properly, rightfully, completely defend myself. See all and know the same as the world and can and does, including my attorney, from all the phenomenal, non-pervasive amount of my entire case being available online globally before my trial, and most important, before I have seen myself. What doesn't anyone know already about my case? How about my side and everything about everything? Be correctly understood that I am not the problem for reasons I am not mal-appointed by the court attorney. Number 8. See my letter 7/21 of 23. Say what I want and should and should, but all the world can, and say it all wrong and warped? Why won't my attorney, this is the preface for the next list, give me an honest answer? Show me everything she says she has and finished reviewing for my case, but withholds from me after I ask repeatedly for and about? Give me an answer other than, I'm putting this to rest, that's not necessary, or I'm not having this discussion with you. Oh my goodness. Grant me access to anything I ask for her in and about my case. Like the detective in my case, stop putting words in my mouth. Tell me what's going on in my case. It's been well over 100 days, and she has been my attorney, and I still do not know anything. 5 years. I still do not know. Ongoing 5 years. Answer any of my questions? Ever ask me any questions? How can she supposedly know everything she needs to know, in quotes, from what she's been told, heard, read, and seen, also in quotes? Reassure they're on my side, for me, not against. Why have I already been judged in the court of public opinion? How did that happen? Why have I been sentenced by anticipation and condemned before my predicted trial? Why does my attorneys and all the world think my case is already over? Your Honor, during our first introduction and my last withdrawal of court-appointed attorney, number 7, Hobson, you stated to me your uninvolvement with any of my letters I write. I am still going to write my letters conduitly. I don't know what she's trying to say here. Consumptively, they are to the world, where all my pretrial jurors are located. She's writing a letter to pretrial jurors. Are located, and this is the only way anyone, including yourself, knows of the very necessary insight to my continued disadvantages, hindrances, impediments I am still experiencing, on top of the new, spurring my new intentions to write. The race to the pulpit is unfair, and it is important to me that you are aware and understand what transpires when my news cameras are off and we're all in between my status hearings. She's written this to us. She's written this to everyone about this. 2, as so many of the advantageous embezzlers, racketeers, mindless lemmings, and just altogether mean people can use their freedom of speech, not knowing me in any way other than what's being said by all the other mean people, and being said incredibly incorrectly, so can I. As the compelling, annoyed detectives in my case, Coaspel had to falsify documents, and Lowen wore his gun for me to see. I am sure you are familiar with, after watching all my plastered, highly misconstrued, over 30+ million views just on one site, interviews, and in which they both repeatedly attempted to feed me their incorrect, incomplete, hypothesized opinion by stating to me, everyone has their limits. At this seemingly endless point of perpetuality of nonsense and lawlessness still growing, and I very much want to advance to the next level. After ongoing 5 years now, a genuine concerned limit has been reached. Why am I still not being included in my case? How much more of my case and self is being added hourly, especially after this letter gets loose, to the internet, increasing the mass infection of destruction of my hopes to have a fair trial? This is legitimate. Anything fair, my side foremost, and wondering now if my attorney drank the punch like everyone else. All aforementioned reasons, and so many more, for this letter to be written, hoping to deter some of the unfair, one-sided finger-pointing of corruption and malpractice being directed at me only by those in the justice system, who are trying to deflect the shame and shock from me, fearlessly challenging the status quo. And it must be so because it's in my face on the computer at the same time on my boob tube television. Wow, that was all hyphenated. It must be so because it's in my face on the computer at the same time on my boob tube television. I've never seen those words together used like that. Brainwashed, ignorant followers of disbelief, conformity, and greed, trying unsuccessfully to make my life by character assassination seem worse than theirs. No, 2, when anyone points their finger, 1, it's impolite, and 2, 3, point back at you. How many of you tried it to see? Put the stone down, and there will be no casting of anything today except maybe for the role of my part. For all the pre-conclusions documentaries and crystal ball real-life stories of true crime incorrectly formulated from everyone supposedly knowing me and judging me, they think I am what really happened, as if going to futuristically. Remember, 3-point back. Soothsaying is not a real job. There's a whole psychic hotline that will differ. We'll take issue with that. To sum it up, in the words of my attorney, after I told her to Google me, she stated, "There's a lot." To sum it up in the words of myself, the defendant stated to my attorney after she stated to me, "What can I see?" or "When can I see? How much longer do I have to wait?" or "How many attorneys must be withdrawn for me to be included in my case, and to be included more than the world presently is. This is my case in every aspect. See all my aforementioned ongoing 5-year questions I am still waiting on for answers. Also, I want to make it known I walked out on my attorney in our last meeting due to her unwarranted, uninformative, unprofessional, snotty attitude and her untruthful answers to my questions and beyond. The retarded, vicious circle, we enter every time we meet is a waste of time. And I'm saying that being in jail with supposed endless amounts of time. How she treats me is extremely prejudiced, hostile, and unconcerned. She is very frustrating, underlined. Number one, to back or to talk or... She's very frustrating. Oh, this is the definition of frustrating. To balk or defeat in an endeavor, to induce feelings of insecurity, discouragement, or dissatisfaction in, or to bring to nothing. So much I preserved my solution in order to coexist with and work together in a happy, progressive, positive, appropriate manner. I added pretend judge to our interactions so she could calm down and ease up on her condescension, offensive demeanor, and obvious prejudgment of she seems like everyone else. Not to remember, I am innocent until judged otherwise. She treats me as if I am not. After my introduction and explanation with pretend judge in the room or on the phone, I am trying to help her understand how she is making herself extremely unwelcoming. The phone is ringing. When in front of a real judge and in the courtroom is how she should treat me, her client, at all times. I should not have to invent pretend judge in order to be and am not at all wrong for wanting to be respected. No matter the outcome, I am innocent until adjudged otherwise. My attorneys, everyone, should be fair, unbiased, trustworthy, honest, supportive, informative, protective, and automatically and effortlessly. I should feel secure, highly confident, proud in her, representing my life. I do not, and have said to her many times regarding her monumental disbelief in me and my case, which I believe contributes greatly to her Sarah, I'm trying here. Greatly to her inimical? What's that word? Inimical? Is there a word there? Inimical attitude towards me. I am hoping by this letter she will pick up the sword of justice and fight alongside, not against me, and so many unmotivated, overwhelmed, weak attorneys prior to who believed our who burned out ungracefully and crept away from the battlefield unsuccessful. My case equals bizarre, equals unknown, equals different, equals ignorance, equals misunderstood, and equals unfair. This does not mean my case can't equal success, and in more than one way. While everyone continues to ring their bells of malevolence, I am ringing mine of hope, honor, plausibility, boldness. Listen, I am not a murderer. The justice system should equal fair, faith, trust, respect, innocent until and if adjudged otherwise. 3-point back. Sarah Boone. Heart, confused cat meme. Yes, thank you. Confused cat meme. June 4th. Video visit. 12 minutes. In addition to my previous letter intended for hand delivery on 6/7 at my status hearing, today my attorney made a video visit to go over everything I've been asking her for and have also sent to her personally in 2 letters, 520 and 525, all on the public video visitation box, where on both sides of me, less than 5 inches away from my visit, other inmates were having their visits also. I have explained to my attorney numerous times previously in writing and verbally that despite the noise level, I do not in any way feel comfortable having in-depth private meetings regarding my entire criminal case on the visitation box, where there is no privacy whatsoever, and held in an open bay dorm with more than 62 other interested, all ears, inmates. I cannot fully participate, if at all, from the entire dorm, officer included, trying to participate also in my case. As always, my attorneys did not listen or care after I repeatedly tried reminding her of my unsecure environment, barking at me I can listen or not, still going over, speaking and not at all allowing me to respond. After repeating to her over and over and over, while she's beginning to speak louder and over me still to please schedule an in-person meeting where we can all be where all can be discussed further, privately, with no success of being heard, I disconnected the visit telephonically. She uncooperatively. She is impossible. See previous letter or ask her for a copy of the 2 I sent her. I was trying to remedy or lessen before sending this to you, Your Honor, and not having to include. Now it's a race to the pulpit. My question, please, who acts like that and still be able to call themselves professional? The visitation box is primarily for families and friends to connect, and if request from an attorney, reminders, notices, quick questions, not high-level confidential case information. She, like other former attorneys who always blame their dysfunctions on me, said, "You don't like the answers I give you." What answers? See pages 1, 2, and 3. We're all in caps here. I am not the problem, except that I want and should be treated fairly, with respect, acting more professional than the paid. I've been doing this for over 40 years, professional. After so long and in all the experience, common courtesy, customer service, and listening skills should have been acquired. All attorneys, do you remember why you even wanted to be one? Remind yourself. No one listens, and it works in everyone's favor but mine, that I'm a murderer, stuck in jail so they can pin on me their uninterested, unmotivated, hopeless, they're going to believe me over her haughty attitude. I am not wrong for not thinking of less of myself because everyone else has and does. This present attorney foremost. The justice system expects me and other inmates, aka clients, to accept its subpar, nonchalant, hypocritical, next on the list attorneys they may keep aimlessly throwing darts for and malappointing, praying they don't withdraw. I have not fired any attorneys appointed in my case. From me expecting the height of equal standards, from me expecting the highest of equal standards possible for wanting the absolute best outcome in my preposterous, mismanaged case. And representing myself is not an option. That's the first time she's addressed this in that way. As both judges have now threatened me with being outspoken and intelligent in my observation of the ongoing abuse I am and have experienced. I have new experiences from it always being the same. Blame Boone. I refuse to be moved in wanting respect, no matter who everyone thinks I am, clarity, inclusion, honesty, and professionalism. And another great reason not to have my case meetings on the public visitation box is my personal confidential inmate information, such as my visitation lists, 2020 through 2023, with names, etc., my interactions with inmates and officers, what I eat, when, and my personal jail calls also being thrown online. For what? To hate me more or to try to get others to because I don't eat breakfast or because I know some Latin? have short hair, my penmanship is nice, or because I'm not getting fat and sleeping all day, but rather fully applying myself, fighting still, making everyone upset from not having to fabricate, mediate, splice, edit. The world apparently knows all. What's next? How many times I go to the bathroom and what function I perform? No one knows anything, nor seems to want to from being comfortable in their corruption and striving to be on top with ratings, web hits, and money. My case details, if anyone forgot, and if you think about it, all that keeps getting plastered and plagiarized, posted, and poked fun at about me, it's all in my favor. Proving myself right about all the mindless lemmings, shut-ins, and justice system advantageously abusing and profiting from everything in my case before my trial and before I've seen. Please be sure to read my attachment for FRCP Rule 3.220, Part E, restricting disclosure. Am I the only one who thinks of these things? When can I win? In anything. It's coming. I'm not the problem, and if anyone were to slip on my slides and have to experience, tolerate, deal with any of what I have and am, would bravely be doing the same. Don't knock it till you try it. 3-point back, race to the pulpit. Again, always, Sarah Boone. FRCP does not apply because this is not federal. Thank you on civil law. Slip on her slides is what she says. 3-point back is the overarching theme. West Florida statutes annotated. Florida rules and criminal procedure 3.220. Part 6, discovery. A, notice of discovery. She's just handwritten the law here. She's copied it word for word. Notice of discovery. After the filing of the charging document, a defendant may elect to participate in the discovery process provided by these rules, including the taking of discovery depositions, by filing with the court and serving on the prosecuting attorney a notice of discovery, which shall bind both the prosecution and the defendant to all discovery procedures contained in these rules. Part B, prosecutor's discovery obligation. Within 15 days after service of the notice of discovery, the prosecutor shall serve a written discovery exhibit which shall disclose to the defendant and permit the defendant to inspect, copy, test, and photograph the following information and material within the state's possession or control. A list of the names and addresses of all persons known to the prosecutor to have information that may be relevant to any offense charged or any defense thereto, or to any similar fact evidence to be presented at trial under Section 90.4042 Florida statutes. B, the statement of any person whose name is furnished in compliance with the preceding subdivision. The term statement, as used herein, includes a written statement made by the person, signed or otherwise adopted or approved by the person, and also includes any statement of any kind or manner made by the person and written or recorded or summarized in any writing or recording. The term statement is specifically intended to include all police and investigative reports of any kind prepared for or in connection with the case, but shall not include the notes from which those reports are compiled. C, any written or recorded statements and the substance of any oral statements made by the defendant, including a copy of any statements contained in police reports or report summaries, together with the name and address of each witness to the statements. D, any written and recorded statements and the substance of any oral statements by a co-defendant. E, those portions of recorded grand jury minutes that contain testimony of the defendant. F, any tangible papers or objects that were obtained or belong to the defendant. G, whether the state has any material or information that has been provided by a confidential informant. H, whether there has been any electronic surveillance, including wiretapping of the premises of the defendant or the conversations to which the defendant was a party and any documents relating thereto. I, whether there has been any search or seizure and any documents relating thereto. J, reports or statements of experts made in connection with a particular case, including results of a physical or mental examinations and of scientific tests, experiments, or comparisons. K, any tangible papers or objects that the prosecuting attorney intends to use in the hearing or trial that were not obtained from or that did not belong to the defendant. L, any tangible paper objects or substances in the possession of law enforcement that could be tested for DNA. And M, whether the state has any material information that has been provided by an informant witness. All those need to be turned over. If the court determines in camera that any police or investigative report contains irrelevant, sensitive information interlaced with other crimes or criminal activities, or interrelated with other crimes or criminal activities, and the disclosure of the contents of the police report may seriously impair law enforcement or jeopardize the investigation of those other crimes or activities, the court may prohibit or partially restrict the disclosure. 3. The court may prohibit the state from introducing to evidence any of the foregoing material not disclosed, so as to secure and maintain fairness in the just determination of the cause. That means if they don't turn over discovery, they can't use it in the case. That's what she's getting at. So she wants a copy of everything, which her attorneys should have. As soon as practicable, after the filing of the charging document, the prosecutor shall disclose to the defendant any material information within the state's possession or control that tends to negate the guilt of the defendant as to any offense charged, regardless of whether the defendant has incurred reciprocal discovery obligations. You have to disclose stuff that will prove their innocence or could be used to defend themselves. D, defendant's obligation. 1, if a defendant elects to participate, or it's got a 1 and then an A. Okay. If a defendant elects to participate in discovery, either through filing the appropriate notice or by participating in any discovery process, including the taking of a discovery deposition, the following disclosures shall be made. A, within 15 days after receipt of the defendant of the discovery exhibit furnished by the prosecutor, pursuant to subdivision B1A of this rule, the defendant shall furnish to the prosecution a written list of the names and addresses of all witnesses when the defendant expects to call as witnesses at the trial or hearing. When the prosecutor subpoenas a witness whose name has been furnished by the defendant, except for a trial subpoenas, the rules applicable to the taking of depositions shall apply. B, within 15 days after receipt of the prosecutor's discovery exhibit, the defendant shall serve a written discovery exhibit which shall disclose to and permit the prosecutor to inspect, copy, test, and photograph the following information and the material that is in the defendant's possession or control. I think she's just copied all of the Florida code into her letter here. The statement of any person listed in the subdivision, D1A, other than that of the defendant, reports of the statements of the experts that defendant intends to use as a witness at trial or hearing, made in connection with a particular case, including results of physical or mental examinations and of scientific tests, experiments, or comparisons, and any tangible papers or objects that the defendant intends to use in the hearing or trial. Pause for the police to go by. The prosecutor and the defendant shall perform their obligations under this rule in a manner mutually agreeable as ordered by the court. The filing of a motion for protective order by the prosecutor will automatically stay the times provided for this subdivision. If a protective order is granted, the defendant may, within 2 days thereafter or at any time before the prosecutor furnishes the information or material that is subject to the motion for protective order, withdraw the defendant's notice of discovery and not be required to furnish reciprocal discovery. E, restricting disclosure. The court, on its own initiative or on motion of counsel, shall deny or partially restrict disclosures authorized by this rule if it finds there's a substantial risk to any person of physical harm, intimidation, bribery, economic reprisals, or unnecessary annoyance or embarrassment resulting from the disclosure that outweighs the usefulness of the disclosure to either party. F, additional discovery. On a showing of materiality, the court may require such other discovery to the parties as justice may require. H, sanctions. There's an asterisk there. If, at any time during the course of the proceedings, it is brought to the attention of the court that the party has failed to comply with the applicable discovery rule, the court may order the party to comply with the discovery or inspection of materials not previously disclosed or produced, grant a continuance, grant a mistrial, prohibit the party from calling a witness not disclosed or introducing in evidence the material not disclosed, or enter such an order as it deems just under the circumstances. 2, willful violation by counsel or a party not represented by counsel of an applicable discovery rule. I think that's key. A party not represented by counsel. She is represented by counsel. I think that's important here. Or an order issued pursuant thereto shall subject counsel or the unrepresented party to appropriate sanctions by the court. The sanctions may include, but are not limited to, contempt proceedings against the attorney, or unrepresented party, as well as the assessment of costs incurred by the opposing party when appropriate. Every request for discovery or response or objection, including notice of deposition made by a party represented by an attorney, must be signed by at least one attorney of record. For her to get this, her lawyer has to submit it. She can't file her own motion here while she is represented by an attorney. As defined by Florida Rule of General Practice and Judicial Administration 2.505, in the attorney's individual name, whose address must be stated. A party who is not represented by an attorney must sign the request, response, or objection and list his or her address. The signature of the attorney constitutes a certification that the document complies with Florida Rule of General Practice and Judicial Administration 2.515. The signature of the attorney or party constitutes a certification that the signer has read the request, response, or objection, and that to the best of the signer's knowledge, information, or belief formed after a reasonable inquiry, it is A, consistent with these rules and warranted by existing law, or a good faith argument for the extension, modification, or reversal of existing law. B, with a star by it, not interposed for any improper use or purpose, such as to harass or to cause unnecessary delay or needless increase in cost of litigation. And C, not unreasonable or unduly burdensome or expensive given the needs or the case and the importance of the issues at stake in the litigation. Pretrial conference. The trial court may hold one or more pretrial conferences to consider such matters as will promote a fair and expeditious trial. The defendant must be present at any pretrial conference unless the defendant's presence is waived in writing or on the record by the defendant or by the defendant's counsel with the defendant's consent. This is something she says she has never waived, and she has objected to anything that has happened outside of her presence. And I say she is right. If she has never waived that, that is a big problem. The court may set, and upon the request of any parties, must set a discovery schedule, including a discovery cutoff date at the pretrial conference. This page intentionally left blank. I don't know why. That the individual shall have full protection in person and in property is a principle as old as common law, but it has been found necessary from time to time to define anew the exact nature, excellence of such protection. Political, social, and economic changes entail the recognition of new heights, and the common law in its eternal youth grows to meet the demands of society. What is she copying this from? Where's this quoted from? This is like it's the law dictionary. Okay, I was like, this is not her normal voice. Thus, in very early times, the law gave remedy only for physical interference with life and property, for trespasses viet arms. Then the right to life served only to protect the subject from battery in its various forms. Liberty meant freedom from restraint, and the right to property secured in the individual, his lands and his cattle. Later, there came a recognition of man's spiritual nature, of his feelings and intellect. Gradually, the scope of those legal rights broadened, and now the right to life comes to mean the right to enjoy life, the right to be let alone, the right to liberty secures the exercise of expansive, I think she means, not expensive, privileges. And the term property has grown to comprise every form of possession, intangible and tangible. And that's the Bolivar Law Dictionary, the 2012 edition. It's a little older, but I think it's still good. The American Declaration of Independence, 1776. We're going way back on this one. We hold these truths to be self-evident, that all men are created equal, and they are endowed by their Creator with certain inalienable rights. That among these are life, liberty, and the pursuit of happiness. That to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. Florida Constitution, 2024. We, the people of the state of Florida, being grateful to the Almighty God for our constitutional liberty, in order to secure its benefits, perfect our government, ensure domestic tranquility, maintain public order, and guarantee equal civil political rights to all, do ordain and establish this Constitution. Client. A person who relies on the professional services of another. The client of attorney is the person or entity represented and advised by the attorney. A client relationship commences for an attorney with an agreement, with the performance of service in reliance on a request for representation or with a statement of representation on which the client relies. All attorneys owe a client a duty of zealous representation, balanced by the obligation to serve justice and to act as an officer of the court. Attorneys also have an obligation to keep the confidence of a client at all times and to keep the client informed of all matters related to the client's interest, to inform the client of law related to the client's affairs, and to defer to the client's decisions, although the attorney has no obligation to the client to perform or refrain from any act contrary to the highest standards of professional responsibility and the law. Attorney-client privilege, big star by this one too. One of the oldest recognized privileges for honest, equitable, confidential communications intended to encourage open, full, and frank communication between attorneys and their clients, thereby promoting the broader confidence correspondence in accordance to the appropriate observance of the law and the administration of justice. She's once again, she's copying out of the dictionary here, I think. Zealous advocacy. An attorney must represent each client to the fullest extent under the law and requires representation to the attorney's fullest abilities without violating the rules of professional responsibility. It requires not only representing each argument required by a client to every institution in which that client has business, but also framing each argument in the strongest terms of law that greatly benefit the client, while remaining faithful to the facts and the law itself. That last part is a big kicker in this case. Zealous advocacy is a requirement of the oaths required by attorneys admitted to the success of the adversarial system of justice. Disruptive, disrespectful, degrading, or any disparaging rhetoric is never an inclusion of zealous advocacy, and the use of such crosses the line from acceptable, forceful advocacy into unethical conduct. That's also the Bolivar Law Library. Attorney misconduct, also star by this one, is a failure of an attorney to comport within the rules and accepted professional customs of the bar, and includes any act or omission of duty by an attorney that fails to perform appropriately the office of an attorney as an officer to the court, as a counselor and fiduciary of a client, or as a member of the legal profession. The scope of attorney misconduct reaches also to conduct of attorneys that is harmful to the appropriate reliance of the attorney upon the law and legal profession. Attorney misconduct includes actions of omissions that enable others to cause harm, not just harm caused directly by the attorney, and not all misconduct is subject to remedy or sanctions, although a variety of forms of each exist. Misconduct may always be the basis for a client to remove an attorney from their duty of representation, as is any other cause for the client's loss of trust and confidence in a lawyer. And the attorney's demeanor to determine whether a party's substantial rights were affected based on repeated or persistent objected to misconduct. The district court shall factor into its analysis that the motion, by engaging in continued misconduct, the offending attorney has accepted the risk that the client case may be influenced by said misconduct. Therefore, the district court shall give great weight to the fact that single instances of improper conduct that could have been cured by objection and admonishment might not be curable when that improper conduct is repeated or persistent. Also from the Bolivar Law Dictionary. Duress. We're learning all these words. There's a test at the end, by the way, so I hope you're taking notes. Duress. An unlawful threat that limits person's independence of judgment or action is only improper. And is only improper thereat or condition. This is getting a little sloppy in this part. Such as coercion that limits a person's ability to think or act independently, and the presence of destroys the independence required of the party subject to. I got lost in that one. Duress. Google that on your own. In order to constitute a voluntary consent, it must clearly appear that the search was voluntarily permitted or expressly invited and agreed to by the person whose right is involved. In addition, such person must be cognizant of their rights in the premises. The consent must not be contaminated by any duress or coercion, and the government has the burden of proof. So she's got a definition regarding duress specifically tailored to, it appears, search of private property. Habeas corpus, great writ. A review of the lawfulness of any person's custody or restraint by a government official is a process of judicial review of any person's detention, whether by what does that say? Normalness? Or normal custody? Is it normal? I think it's formal custody. Formal, it's an F. Okay, looked like a D. Formal custody, incarceration, or continuing restraint by an official or agent of the government of a state or federal government. The right of review of custody by habeas corpus is a fundamental constitutional right. It is a bulwark of individual liberty being used to free people by courts without legal authority or without having complied with the requirements of law. Habeas corpus is protected in the U.S. Constitution from interference. A defendant who has been confined for 30 days after their arrest without a trial shall be allowed a preliminary hearing upon application. Informal consent. She crossed out informed consent and wrote informal. Informal consent is consent given with appropriate knowledge after the person giving consent has learned all of the information that would be reasonably required for the basis of a reasonable decision. In many instances, for an institution or professional to prove that the decision maker was sufficiently informed over a matter to give informed consent, the institution or professional will provide the information requisite to make such a decision in an informed way. But the provision of this information is not a legal requirement to receive informed consent unless a custom, statute, or regulation requires it. An attorney or other professional, we're over halfway through, guys. An attorney or other professional has an obligation to provide any person with adequate information and explanation of the proposed course of action and its alternatives for the person to know of the material risks of each before consenting. By definition, professionals and fiduciaries have similar obligations to their clients and to these, with a reasonable right to rely on their information and advice before consenting. The lawyer or other professional shall, 1, promptly inform the client of any decision or circumstances with respect to which the client's informed consent, as defined in Rule 1.0e, is required by these rules. Reasonably consult with client about the means by which client's objectives are to be accomplished. And 3, keep the client informed about the status of the matter. 4, promptly comply with reasonable requests for information. 5, consult with the client about any relevant limitation on the lawyer's or other professional's conduct when they know that the client expects assistance not permitted by the rules of professional conduct or other law. Legal ethics. The professional obligation of a lawyer, including those codified by rule and a body of rules of standards of conduct that legal culture imposes upon its members. Ethical standards arise, as does their authority over the attorney, from the oath of the attorney, the inherent power of the courts to discipline lawyers before the bench, the culture of the profession, and the standards of liability for fiduciaries and professionals. Under these rules, legal ethics usually require attorneys to avoid conflicts of interest, to practice with diligence, to avoid frivolous, false, fraudulent, or harassing behavior, to zealously represent clients, and generally to avoid the appearance of impropriety. A violation of legal ethics subjects the professional to sanctions from the professional bar and courts. Also, copy from the Law Dictionary. Equal protection of the law. Each law should treat similarly situated individuals in a similar manner. Equal protection of the law is one manifestation of the ancient principle of equal justice under the law and is required in the U.S. Constitution by states under the 14th Amendment's Equal Protection Clause and by the national government under the 5th Amendment's Due Process Clause. Equal protection requires each law, whether it is a statute, regulation, order, or application of custom, to treat similarly situated people in a similar way. Abuse of process. A claim for harm from the misuse of a legitimate legal process. This is a claim that can be brought when pleading a procedure is wrongfully employed for the purpose of harassing or injuring the opposing litigant. Examples include filing a false affidavit. My arrest affidavit has someone else's information listed, and also an N, for domestic violence, that then sworn to be true and correct by Conley, Coopsell's C impeachment document. The lead detective in my case, she got a squirrel moment here. The lead detective in my case, what other discrepancies have been made in my case? Making false claims, see interrogations, videos. Introducing fraudulent evidence, statements, assumptions, and guesses. Pleading the abuse of process requires the movement to prove three elements: that the legal process had been initiated properly with the probable cause, the process was subsequently perverted to accomplish an ulterior purpose for which the process was not originally designed, and the perversion caused harm. Abusive process involves the misuse of the process already legally in place, whereby a party attempts to obtain a result not proper under the law. The two essential elements of abuse of process are the ulterior purpose and a willful act in the use of a process not proper in regular conduct or proceeding. This is numbered page 10, but we're far beyond that. Interrogation, examination of a suspect. Oh, she's got something to say here. The process of inquiry by which police or other law enforcement personnel seek information from a person suspected of a crime. Interrogation is distinct from interview, as titled on my transcripts, in that police seek not merely information in general from the suspect, but also statements from the suspect that are either directly or indirectly incriminating. This may involve direct questioning or other action designed ultimately to elicit such an incrimination and is subject to the due process of law without any compulsion of any kind. Interrogation, as conceptualized in the Miranda sense, reflects a measure of compulsion above and beyond that inherent in custody itself, referring not only to the express questioning, but also to any words or actions on the part of the police, other than those normally attendant to arrest and custody, that the police should know and are reasonably likely to elicit an incriminating response from the suspect. Custodial interrogation. Everything has an asterisk now. It's all asterisks from here on out. Interrogation of a person in the custody of law enforcement officials is following a person's arrest or custody. The hallmark of custodial interrogation is that the person knows that the person is in custody and has no freedom to leave. I did not know I was in custody and could not leave. I was told by Cospel, that's one of the interviewers, to come pick up my phone, in quotes, not warning of being interrogated again. Being custodial interrogation, the stakes of interrogation are higher than when a person is free to go, and any statement made in the custody during is presumed to be coerced under the Fifth Amendment. She's saying that her statement when she showed up at the police station was coerced. That's her defense right now. The constitutional disclosure of Miranda is that self-incrimination flowing from custodial interrogation is, ipso facto, compelled self-incrimination because of the inherent coercion, the inherent compulsion of the custodial interrogation environment. I don't think she's going to win this argument. Excited utterance. This is an exception to the hearsay rule. Let's see what she uses this on. Spontaneous declaration or spontaneous exclamation. An unthinking statement made at a moment of great surprise and stress. An excited utterance is a statement made during or immediately after the declarant is surprised by a startling event or condition, while the declarant is under the stress of excitement caused by the event or condition. And we have a map, ladies and gentlemen. We have a map with stars all over it. I'm trying to see where are the stars. Publicity, exploitation, and saturation. We're on the list. We're on the list. North Carolina has a star near my whereabouts. I think we've been busted, guys. Let's see. North America, Canada, North America, tagged. Alaska knows nothing about this, apparently. We have England. Somewhere over, I'm not very good with my, is that Japan? Taiwan? I don't know where that is. Publicity, exploitation, and saturation. United States map, page 1. To date, each star is a state where I have received correspondence via mail or message regarding my current criminal case. World map, page number 2. To date, each star is a continent where I have received correspondence via mail or message regarding my criminal case. The number grows daily. Most all letters and messages are available for review and understanding of the impact of my case, details being made readily available on the global internet, creating wrongful ignorance, hate, and massive prejudgment before my trial. I, the defendant in my case, have not yet, ongoing 5 years, fully reviewed or even seen all of my case details. Everyone in the world has already had the opportunity to do so themselves. The continuation of the obvious exploitation allows the world to keep pressing their incorrect, presumed unfair theories, ideas, accusations, forcibly insinuating I committed criminal acts. My present attorney said it is not necessary to receive a court order. I've been trying to obtain download my case information to apply from the OCCD tablets. My former attorneys are withholding some of my case contents I have supplied to them, and which have been deemed lost. Many other items have been returned, not to myself, but to the next attorney, and which have been unable to be located to date. I am missing innumerable case items, which I continuously request to be returned or obtained without success. Invasion of privacy, Supreme Court, wrongful conduct. Appropriation, the unlawful use of a person's name or likeness to obtain some benefit. Intrusion, physically or electronically intruding into one's private quarters. Public disclosure of private facts, the dissemination of truthful private information which a reasonable person would find objectionable. False light in the public eye, publication of facts which place a person in the false light even though the facts themselves may not be defamatory. Defame, to injure or destroy the reputation by libel or slander. Anything is defamatory if it has a tendency to render the party about whom it is published contemptible or ridiculous in public estimation, or expose them to public hatred or contempt, or hinder virtuous men from associating with him. An opinion can be actionable if it implies the allegation of undisclosed defamatory facts as the basis for the opinion. Invasion of privacy, false light, publicizing some matter to create a false and harmful impression. False light is both a theory of invasion of privacy and, in some jurisdictions, an independent cause of action arising when a person gives publicity to a matter concerning another person that places the victim before the public in a false light. That would be highly offensive to a reasonable person. When the persons giving or creating the public publicity either had knowledge of the false light that would result, or acted in reckless disregard of the falsity of the publicized matter or the false light in which the other would be placed. In order to state a claim for false light invasion of privacy, the person need not prove that they have been defamed. Rather, it is enough that they are given unreasonable and highly objectionable publicity that attributes to their character, conduct, or beliefs that are false, or that attributes to their character, conduct, or beliefs that are false, and is so placed before the public in a false position. The line is drawn when the publicity ceases to be the giving of information to which the public is entitled and becomes a morbid and sensational prying. Ooh, the handwriting changed here. We've got this. This is important. Take notes on this part. Publicity, exploitation, and saturation. My personal, individual criminal case is being advantageously exploited and abused from all my significant life-saving suppressible case details, evidence, proof being illegally obtained by coercion, trickery, duress, confusion, and without my permission, in any form, written or verbal, to anyone, then broadcasted, distributed, hand-delivered to the entire planet, states, countries, and continents, containing all of my personal containing all my potential jurors, causing irreparable erroneous falseness, greatly tainting my jury pool altogether by forcibly attributing heavily influenced, incorrect, inappropriate motives, theories, and ideas. This obvious exploitation of invasion of my privacy is creating unnecessary, unlawful oppression, depleting all of my entitled opportunities to be given a fair, proper, successful conclusion of my case. I disagree with how she gets there, but the fact that her case is getting more and more notoriety does cause problems for a fair trial. It will be more challenging to seat a jury that's impartial because of this. The misprejudgment has already been made unfairly against me from the undeniable violations of my constitutional rights and due process of law. As a result of my entire case and personal life being publicized globally before my rightful trial, which lawfully, ethically should be without disadvantage of freedom, all partiality, deceitfulness, and dishonesty made from said evident exploitation. Definitions collected from the Bolivar Law Library, Merriam-Webster's Dictionary, and Smart Communications Tablet. Smart Communications Tablet. What is one of those? Exploit. Unfair or irrational use, the taking of unfair or unreasonable advantage of a person, thing, resource, or circumstance. Exploitation means an unjust or improper use of the resources of a vulnerable adult for the profit or advantage, monetary or otherwise, of a person other than the vulnerable adult through the use of undue influence, coercion, harassment, deception, false presentation, or false pretense. Abuse, a corrupt practice, to put to a wrong use, to misapply or misuse, to pervert application and and for a wrong purpose. Significant, deserving to be considered, important, monumentous, having meaning, likely to have considerable influence or effect. Suppress, the restriction of a person's action or speech to keep from being known, to stop the publication of or circulation, to hold back. Illegal, not lawful or sanctioned by official rules, not according to or authorized by law. Illicit. Coerce, to restrain, especially by law or authority, to repress, to compel or constrain to any action as to coerce someone to vote for a certain candidate. She's got definitions that are pulled from a different vernacular. Like this is clearly a voting issue, right there. But it works. We'll roll with it. Trickery, deception by trick and stratagems. Fraud. Duress is the state of compulsion or necessity which a person is influenced, hardship, pressure, and constraint. Confusion is to make mentally unclear or uncertain, to disturb the composure of, the state of being mixed or blended to produce indistinctness or error, to cause or make disorder, tumult. Broadcast, scattering in all directions, to spread widely, make widely known, or to over a wide area, the transmission of sound or image by radio or television, cast or dispersed in every direction. Distribute is to divide among several or many, to deal out, a portion, a lot, or to spread out. Deliver is to send to an intended target or destination, convey, transfer, or release, to give or yield possession or control of, to make over to the knowledge of another, to give forth in action or exercise. Irreparable, impossible to make good, undo, repair, or remedy, not repairable, not capable of being recovered, regained, irretrievable. Erroneous, incorrect, wandering, straying, deviating from the right course, misleading, and mistaken. Falseness, you guys are taking notes, right? There is a test at the end. Falseness, not genuine, artificial, intentionally untrue, adjusted or made so as to deceive, tending to mislead, inaccurate based on mistaken ideas, contrivity to the fact, double dealing, perfidy. I'm learning so much today. Taint. Please tell me you wrote the right description here. Ian, help me here. Taint, corrupt, contaminate, to affect or become affected with something bad, a contaminating mark or influence, to imbue with something extraneous, especially with something poisonous. Force, strength or energy of exceptional degree, active power, capacity to persuade or convince, an influence that causes motion or a change of motion. Influence, the act or power of producing an effect without apparent force or direct authority, the power or capacity of causing an effect in indirect or intangible ways, to sway, to have an effect on the condition or development of by gradual process, controlling power quietly exerted. Incorrect, not correct, not according to established rules, inaccurate, faulty, not in accordance to a copy or model of testimony, not true, wrong. I was tempted to do a voice impersonation, but I won't. Inappropriate, fitted to a wrong purpose or use. Motive, something as a need or desire that causes a person to act, that which produces conception, invention, or creation in the mind, a guiding or controlling idea, or relating to emotion. Invade, a warlike or hostile entrance into rights, possessions or domain of another. Trespass, to enter for conquest or plunder, to spread through and harm. Privacy, the quality or state of being apart from others. Secrecy, a place of seclusion from company or observation. Oppression, this is the longest vocabulary list ever. I'm used to like 10 words a week, just 10 words. We're on word 24 already. Oppression, hardship or injustice, to impose excessive burdens upon, to overload, to treat with unjust rigor or cruelty, to crush by abuse of power or authority, to weigh down, persecute, wrong. Deplete, to reduce by destroying or consuming the vital powers of, the extension of strength or resources, to empty or unload. Entitle, to give a right or claim, to qualify for, to furnish with grounds for seeking or claiming with success, to attribute or subscribe. Fair, conforming with the rules, free from obstacles of hindrances, unobstructed, characterized by honesty, impartiality, without any suspicion, bias, any marked characteristic. Proper, marked by suitability or rightness in all aspects, appropriate, excellent. Excellent, dude. Successful, resulting in success, accomplishing what was proposed, favorable or desirable outcome, the result of an undertaking, endeavor, or effort. Prejudgment, to judge before a hearing or full and sufficient examination, to decide or sentence by anticipation, to condemn beforehand. Unfair, marked by injustice, partiality, deception, unjust, not fair or honest, disingenuous, using or involving trick or artifice, unequal. Undeniable, plainly true, incontestable, unquestionable, not deniable, indisputable. Violate, break, disregard, or interrupt or disturb, to abuse, infringe, non-observance, the violation of law or positive command of covenants, promises, anything that should be held sacred or respected, and the contemptuous treatment thereof. Constitutional rights, a right protected under the Constitution of the United States of America, and the most contemporary sense of right, which implies a greater emphasis on the idea that right is conferred upon the person by the Constitution, and without a Constitution, the person would have no rights. The enforcement of constitutional rights is a matter not only for the courts, all branches of government also. Liberty right, the constitutionality protected, albeit ability, to engage in certain conduct or hold a certain status, and in doing so to be protected from interference by police or other agents of the government, unless that interference is well justified and legal. The right to privacy and freedom of speech are examples. Privilege, or positive right, sometimes called Claim right. The constitutionality protected ability to call upon agents of the government to assist in performing certain conduct or to hold certain status, and in doing so to be protected from the interference by other government agents by private parties. Procedural right. The Constitution requirement enforcement by the citizen that agents of government act only in certain ways, according to certain rules, and in consultation and agreement with one another. The rights to laws made according to specified procedures, to trial by jury, and to be free from torture are examples. Fundamental to all these rights is a constitutional right in each individual that the agents of the government will abide by the Constitution and do nothing through the power of the state that is not allowed to them to do so by the Constitution. The right not to be taxed for unlawful purposes is an example. Due process. Constitutional rights in life, liberty, and property, interests that cannot be burdened without due cause or appropriate procedures. Due process of law is a fundamental aspect of law, including not only the process by which law must be created and applied, but also the scope within which certain laws must be made and enforced, and beyond which laws ought to leave individuals to their own liberty. The Due Process Clause of the 14th Amendment prohibits state governments from depriving any person of life, liberty, or property without due process of law. Thus, due process of law includes both a procedural and a substantive aspect. Procedural due process rights are meant to protect persons from mistaken or unjustified deprivation of life, liberty, or property, and entitles a person to an impartial, disinterested tribunal in both civil and criminal cases, protecting two central concerns: the prevention of unjustified or mistaken deprivations of the promotion of participation and dialogue by affected individuals in the decision-making process. I think it said two things, but I only saw one in there. Substantive due process rights are those fundamental rights and liberties which are objectively deeply rooted in this nation's history and traditions. They are those rights implicit in the concept of ordered liberty. No man of what estate or condition shall be put out of land or tenement, nor taken, nor imprisoned, disinherited, put to death without being brought in answer by due process of law. Analysis of either is a procedural or substantive due process claim must begin. Analysis of either a procedural or substantive due process claim must begin with an examination of the interest allegedly violated and the possession of the protected life and liberty or property interest is a condition precedent to any due process claim. Publicize, to bring to public attention, to advertise. Rightful, having the right or just claim according to the established laws, belonging, held, or possessed by right, consonant to justice. Lawful, permitted, constituted, or authorized by law, rightful, legitimate, competent. Ethical, conforming to accepted and professional standards of conduct or belonging to morals, treating to the moral feelings and duties according to, in harmony with moral principles or character. Disadvantage, an unfavorable, inferior, or prejudicial condition, quality, or circumstance, unequal portion in society, less or damage especially to reputation or finances, loss or damage. Partiality, inclined to favor one party in a course or one side of a question more than the other, biased, not indifferent, having a predilection for, inclined to favor unreasonably, special taste or liking. Deceitful, an attempt or deposition to lead into error, any trick, collusion, contrivance, false representation or underhanded practice used to defraud another, fraudulent causes to believe what is false, entrap, seduce by artifice, and mislead. Dishonesty, void of integrity, faithfulness, disposed to cheat or defraud, violation or trust of justice, unworthy, want of fairness, to betray. Evident, clear to the vision and understanding, satisfactory to the judgment, apparent. Excited utterances are admissible evidence despite both the hearsay rule and the confrontation clause, because they are only admissible when the circumstances of the statement are sufficient to demonstrate that the statement was an unthinking, unplanned reaction to events. To introduce an excited utterance, the proponent must demonstrate that the statement was made during or following a startling event or condition, that the statement was made while the declarant was under the stress or excitement caused by the event or condition, and the statement relates to the startling event or condition. The manner in which the excitement is caused may be direct, as when the declarant is a participant in the event or a witness to it, or indirect, as when the declarant learns of the event later. By definition, a statement may be excited utterance and not perfectly contemporaneous with the event, but it must be made while the emotional state caused by the event or condition persists. Many, though not all, statements that are excited utterances are also forms of statement or present sense impression. Coercion. Unlawful force, fear, or threats used to spur another to conduct. It is the influence, compulsion, or restraint that diminishes free will and causes them to do or to refrain from doing anything. It is the basis for the crime of criminal coercion, which is a form of blackmail. Freedom of Information Act, FOIA, I like this one. A federal or state statute requiring government agencies to release information on request. It is a statute that requires the dissemination of information held by government agencies through regular publication of such information or by the release of such information only by request. The 9 categories of government information exempt from Freedom of Information Act are, and then it says 7, law enforcement's records. If their production could reasonably, I have to turn my picture off here. If their production could reasonably be expected to interfere with enforcement proceedings, to deprive a person of a right to fair trial, or an impartial adjudication, to constitute an unwarranted invasion of personal privacy, to endanger the life or physical safety of an individual. That was the last page. We had 58 pages of letter. If you missed it, we had a few pages before this point. Wow. Let me summarize this a little bit, okay? Because I feel more and more that she is right about some things and wrong, like dead wrong about others. But let me break this down just a little bit. First of all, she's talking to the judge. She has sort of given up on the counting that we've seen in other letters, where she says how many days, how many hours, how many visits, how many anything. Because in this case, her lawyer is meeting with her, but now she doesn't like the way the meetings are going. So she's complaining. She's saying, why can't I do the things that I want? Why can't I have access to all my records? Why can't I, get everything about my case and hold it myself? The fact is, she has representation. And according to the courts, they believe that all that stuff is held by her lawyer, who is representing her and who is using that to build her case. She has a couple arguments in here that seem a little bit off, meaning that she thinks that an attorney is required to do everything you want them to do as long as it's legal. And I think the attorney is more required to provide the best defense they can while still following the law and the facts. So they have to weigh the situation, the cards they've been dealt, and move forward the best way they know how. She wants a specific route, and her attorney is not doing that. But she has voiced an opinion quite strongly, where she's opposed to, quite literally, what I am doing right now. At least that's what she says in the letter. But some of her letters, including this one, is in a way addressed to those who are doing this, where she's saying, I am rushing to the pulpit. I'm trying to get my message out first. And so I'm going to use this system, which I'm not happy with. Now with feeling cachette. What was wrong with the first one? Did we figure out the meaning of 3-point back? Yes. She's saying when you point a finger at somebody, you have one finger going forward and 3 more are pointing back at yourself. She's saying in a biblical sense, it would be he who was out without sin cast the first stone, which is generally good practice. There are some other sayings, don't throw rocks from a glass house. There's some other little phrases that go along with that. But they're saying, hey, she's saying, you're accusing me of all this. You're saying that I'm the crazy, that I'm the murderer, that I did X, Y, Z, that I'm guilty of these crimes. But, look at yourself. Let's see, more complaints. it breaks down to a couple things. Why can't I have this? Is the list of mostly. Why can't I have my court date when I want it? Why am I still here in custody and not have my day in court already? Why don't I have all the evidence that I want in my my boxes of trial prep information? I think I'm missing some, and I should be entitled to it. She lists it many different ways. Why can't I have somebody who represents me when it comes to the lawyer? Why can't I have an attorney who treats me the way I want to be treated, instead of comes in and says, this is what we're going to do? She says, I want the lawyer to listen to me and them to do what I say, instead of them coming and telling me this is what we're going to do. And she's accusing her current lawyer, Cashman, who has requested to be released. She's already filed the motion to be removed from the case. She's saying that she puts words in her mouth, that she's not listening, that she's basically looked at this case and determined that it's a done deal and it's decided, and that she's guilty. She addresses in here a big issue, and she hits it from several different angles, and it's a legitimate one, that her potential jurors, which would be assuming that the case is not moved, that she doesn't get a change of venue, would be people who would be called to serve in jury duty from the county in which she's in. Okay, Orange County is currently where she's at, where it's expected her trial's going to go forward. So the people in Orange County, anyone on the the voter records or driver's license list, could be called in. Any citizen could be called in and possibly serve on the jury. She is looking at a broader perspective and looking at the world as her potential jurors, when in reality it's pretty much just Orange County that she should be concerned about, unless there's a change of venue, and then it takes it to another county over, one or two away. But she looks at it and says, because of the global reach of my case, I can't have a fair jury trial. Really, she has to look at the reach within her own county and see if it's the same. You can't just say, because the whole world is talking about this, my county is also talking about it. It might not matter to the people of Orange County. Okay, there may be more people outside of Florida that are following this than on the inside. I'm sure there are. Okay, so she also made some clarifications that she's never fired a lawyer, sort of adding to the delay issue, which is a legitimate delay issue as well. She has her right to a speedy trial. She says, she doesn't mention it in here, but in previous letters she said, I've never waived that right to a speedy trial. You guys say that I have. If you look in the docket, I think it was November or something, the first year that she was incarcerated, the docket shows that it was waived. But that cannot be waived by her counsel without her, I believe it requires written consent. And there's no copy of her written consent in that. So she might have a valid argument there. Either way, I do believe that this case, 5 years is a long time to wait. Koberger's case isn't going to take that long to go to court. Okay, let's see. She talked about the jurors. She's got disadvantages because of all this information going out. She has a belief that her information, specifically like her letters to court, should be private. And that's, unfortunately, the way the law works in Florida, that's just not true. When you write the judge a letter, it is a public document, and it is disclosed automatically unless certain conditions exist. Florida is the Sunshine State. They literally open the books, and it doesn't require a FOIA request going in and saying, I want a copy and I'm going to pay for this many pages to be copied and pay for the research for you to do it. By default, Florida says, come look at it. Come and get it. Okay, especially Orange County. They're very good this way. There are some things that can be filed under seal. These letters are not done that way. And honestly, I think with her having representation, her writing a letter that bypasses her representation, goes straight to the court, I don't think she can do that under seal. You'd sort of need the lawyer to negotiate that. And even then, it might be objected to by the other side. Okay, she calls out her detectives a little bit, and this gives us just a little glance, probably the most in-depth view into her idea of defense that we've seen yet to date. And she is questioning the behavior of the detectives, particularly in her interview or interrogation. So she's thrown a lot of definitions out there, and I think she's trying valiantly to make it look like the situation surrounding her interrogation, which is the one that was on video and you can find online a million different places. We've covered it as well. It's the not intentionally interrogation, but she's trying to set up the stage as to show that possibly there was some excited utterances, which would be allowed in. I'm not sure why she's focusing so much on that hearsay exception, unless she wants to also say that you can't call what I said in there excited utterances because it was not in the moment. It was well after the fact that we knew that he had passed away. Thus, you can't bring in a hearsay statement. But it was a police interview. It's going to be heard. It's going to be seen. I don't know. It would take a pretty miraculous situation, in my mind at least, for her police interview to not come in to trial at this point. And it is pretty damning, because we do have within that interview some statements that are problematic for her, specifically positions that change even within the interview as to alcoholic consumption during the night, what they were doing exactly, statements that she now has to own in court and stand by, like the not intentionally part, which isn't going to really hold up. So she says over 30 million views. She's added up a lot of the views on some of the bigger channels, I think, and most likely YouTube, because television itself, which has also aired a lot on her case, it's harder to get stats on that. Those are not things that just give out. So I think she's looking at YouTube and a few channels that add up on her case, on her interview. But 30 million views there, just on one site. Probably Court TV or Law and Crime is my guess there. Let's see. She says, I want to advance to the next level after ongoing 5 years now. A genuine concern has been a genuine concerned limit has been reached. She wants to be included in the case. This is legitimate from the beginning as well. In Florida, she has the right. She can say, I'd like to be included in all my hearings. And then pretty much she has to be there for all of them. She has to get notice. She said that previously to the judge and wasn't included in some after that. But the problem is her writing to the judge is not the same as her lawyer filing a motion that she be included in everything. And so I don't know if that's a problem or not, because she has representation. She has someone else who's paid to be her go-between between her and the judge. This just accounts, this letter is just like, oh, and we have this as a side note. I'll read it. I'll put it in the record, but that's not really what we're here about. Okay. Lots of talk about how things are not fair. How she's seen very much that as an incarcerated person, it's very difficult to get everything you want when you want it. She's at the whims of the justice system and the schedules of the justice system. So she is constantly seeking and having difficulty receiving the things that she wants related to her case, and some things she just doesn't have. This part was quite interesting. I'll read it here. She's talking about all aforementioned reasons, and for so many more, for this letter to be written, hoping to deter some of the unfair, one-sided finger-pointing of corruption and malpractice being directed at me by those in the justice system, who are trying to deflect the shame and shock from me fearlessly challenging the status quo, and it must be so because it's in my face on the computer at the same time on my boob tube television. Brainwashed, ignorant followers of disbelief, conformity, and greed, trying to unsuccessfully to make my life by character assassination seem worse than theirs. That's a long sentence. It's pretty much all of this on the screen is one sentence for the most part. She's got in here. She says it's to the justice system, but I think her complaint would be more to the media, where you have a new name idea. I don't know why she hyphenated all that. Trying to deflect the shame and shock from me, fearlessly challenging the status quo. I don't know why she thinks the justice system is feeling a sense of shame and shock from her challenging the status quo, because her behavior is nowhere near the level of some of the extravagant challenging the status quo that we've seen from other people. But she has it on her computer and on her TV. So that's what she says, on the computer at the same time as my boob tube television. Brainwashed, ignorant followers of unbelief. So this is not the justice system. The judge is not on doing interviews on the nightly news about this case, but she addresses it to the justice system, and then sort of points the finger of blame at the general public and media as well. Constant theme throughout the letter. Let's see, trying to make her life seem worse than theirs. No, 2, when anyone points the finger, 1, it's impolite, and 2, 3 point back at you. And then she did, how many of you just tried to do that? Which is just sort of funny. That's like saying you can't sneeze with your eyes open, and then people trying to sneeze and do it. And how many of you just tried to do that? It's weird, although sneezing is a little hard to do on command. Put the stone down, so there'll be no casting of anything today, except maybe for the role of my part for all the pre-conclusioned documentaries and crystal ball real-life stories of true crime incorrectly formulated from everyone supposedly knowing me and judging where they think I am, what really happened, and what is going to futuristically. So here she's talking specifically, I think, about us. And by us, I'm talking about the true crime side of social media in general. She says, "Put the stone down. Don't be throwing anything at me. It's my turn to throw things at you." Is what I read there. Not liking the crystal ball. I don't know what else is out there. There might be a lot of stuff that talks about her case and speculates on where she is and what's going to happen. But most of what's out there that I've seen is basically her putting stuff out there that we're talking about. We now have a Sarah Boone dictionary of law terms, which we didn't have before, and we'll probably be talking about that. That's probably going to be an issue when upcoming trials, when we have questions, we're like, hey, check Sarah Boone's dictionary, see if it can help us understand this. We have that now, which we didn't have before. That's not us making something up. That's something that she put out there, knowing, because she's known and she's mentioned in every single letter that these all become public. So she is trying to gain the benefit of saying my privacy is being invaded. I'm all my private documents and communications with the court are being spread out there. But she is the one who putting it out there, knowing that that's where it goes. And in some of her letters, she literally is like, hey, to all my fans, to all of you people, here's the latest update. And this one, even though it's not worded exactly like that, is doing the same thing. She tells her lawyer to Google. She says, Google me. And the lawyer said there's a lot. Let's see. So she wants to see all the information. She has a legitimate concern why these attorneys keep withdrawing from her case. I believe, and Sarah, if you hear this, don't get me wrong, when your eighth lawyer has to withdraw from her case, there might be some time for introspection. There might be some aspects of this breakdown of the relationship, attorney-client relationship, where Sarah Boone shoulders some responsibility and possibly could have negated some or all of the breakdown by changed behavior. This is my case in every aspect. 5-year question, I'm still waiting for answers. She walks out of her attorney. This is very interesting. Her saying, I walked out of my meeting with my attorney. She has been begging for meetings with her attorney. And this attorney, she has not complained about. We didn't get in here. This has been so many days since you've talked to me. It's been so many hours. It's been this many times I've tried to phone call you and you haven't answered. It's been, I've left messages this way and this way. I've had friends reach out to you through letters. None of that is in here. This attorney appears to be exactly what she wants as far as scheduling and meeting. Now she starts complaining about how the meeting is held. She says, yeah, she's meeting with me, but it's in like the general visitation. And I'm on the phone here, and I've got like another inmate right there 5 inches from me. And if I start talking about, my case, details about my case, they're going to hear and they're going to talk, and I don't want them to know. Okay, so it's very much an us versus them, which might give us a little insight as to how things are going in prison for her, and it's probably not good as far as her relationship with the 62 other people in her dorm. But the lawyer is not scheduling or not going to the effort to get a big meeting and have her brought in and in his private room, and that's what she wants. She wants to be treated with kid gloves. She's like, I don't want to have to say anything, that other people could hear. And in a way, I see that that's all right, but it's also very likely that the information that the lawyer is communicating to her is not of the nature that needs to be in a private room. She wants it to be in a private room because she wants to tell the lawyer exactly what to do. And the lawyer's like, I don't need that. I don't need you to tell me anything. I have 7 attorneys' notes worth of your case and your position and what you've told them. Okay, every attorney before this I have in front of me, and I've got it all. She says she's very frustrating, but she walked out of the meeting. She literally hung the phone up and walked away because, as she said, and she used this term, she says it was a retarded, vicious circle. We answer every time we meet is a waste of time, and they're incompatible as humans. We watched this in court just the other day, right? We watched a judge up I think it was in Wisconsin, who was overseeing a divorce case, and the two sides could not even talk to each other long enough to figure out how to negotiate getting the cat from one person to the other person. And we have that same situation where now the lawyer is, for all intents and purposes, asking for a divorce from Sarah Boone. She's like, I don't want to be in this relationship anymore. It won't work. I can't do it. Okay, let's see. It's very frustrating. Imagine that feeling is probably jointly shared on both sides. And she starts, this is her first definition where she says frustrating, she underlines it, and then she goes through definitions. Definitions are quite important to Sarah Boone because she feels oftentimes where she uses words. I'm putting words in her mouth here, and she's probably going to not like that. But go back to her interrogation where she said, but it was not intentional. You guys aren't understanding. I say not intentional. You're not understanding what I mean by that. You can't charge me for something that's not intentional. To her, the word meaning is very important. And here, every time she uses a word, she says, and this is the meaning I mean by it. This is what I'm trying to say by using these words. Let's see. I presented my solution in order to coexist and work together in a hopeful, progressive, positive, and appropriate manner. I added pretend judge to our interactions. This part gets me. She invented a fake person to be a third party in their communications. So she told the lawyer, look, maybe this will work better if you pretend the judge is here with me on my side, on this side of the glass. He's also on the phone, but not in the orange. He's in the black, but he's on the phone. Pretend the judge is here and you're talking to him, because you wouldn't be this rude to me if he was here, right? So hey, dial it back. Attorney Cashman, dial it back. Pretend judge is listening. She says, I invented this to our interactions so she could calm down and ease up on her condescension, offensive demeanor, and obvious prejudgment. She seems like everyone else not to remember I am innocent until adjudged otherwise. I think it's adjudicated, but adjudged works. She treats me as if I'm not. So after my introduction and explanation with pretend judge in the room or on the phone, she's like, hang on, attorney, can you wait? Pretend judge is not here yet. We have to wait for him to arrive. The attorney must be like, she's lost it. She's lost it. There's, can we have another chair brought in for pretend judge and make it a soft one? I'm trying to help her understand how she's making herself extremely unwelcoming. This is this must be infuriating to the lawyer who has her work cut out for her in this case. She's assigned to this case, did not choose it of her own make, and yeah. So when in front of a real judge in the courtroom is how she should treat me, her client, at all times. So she's saying, Judge, you don't see what's happening when you're not here. That's why I invited Pretend You to come watch, and I'll tell you what happens that Pretend You can't tell you. But like, yeah, in court, she's all nice and, hey, let me consult with my client. But behind closed bars, not so much. I do believe that she does have the right to be treated respectfully by her lawyer. Yeah, Cashman has 40 years of experience. This is not a newbie, wet behind the ears a lawyer. This is an experienced trial attorney who she's lucky to have, but she wants to be treated in a certain way. She is not able to separate, from what I can read here, she's not able to separate the facts that the lawyer is presenting and saying, based on what the facts are, this is what we have to do but I want you to do this. And if you won't do this, then you are not treating me nicely. And she can't separate those. To Sarah Boone, it is not, there doesn't seem to be a clear line of distinction there. But she says she should be fair, unbiased, trustworthy, honest, supportive, and informative, protective, automatically and effortlessly. And instead, her lawyer is more of, a realist. I should feel secure, highly confident. You're very secure right now, but highly confident, proud in her representing my life. I do not and have said to her many times regarding her monumental disbelief in me and my case, which I believe contributes greatly to her imical. I think it's imical. I don't know what that word means. Sarah Boone will need one more word added to the dictionary. Attitude towards me. Hoping this letter. I'm hoping by this letter, she will pick up the sword of justice and fight alongside, not against me. This means that she's probably copied her attorney on this. Okay. And her attorney's just like, great. One more letter, because yes, this goes to the judge. Yes, this goes to her attorney, but yes, this also goes to the prosecution. They also get this. And if there's anything in here that they want to, it's sort of injustice. Pick up the sword of injustice. I did not catch that red pen. She wants her attorney to pick up the sword of injustice. That's terrible. That's terrible. Oh, man. Good catch, red pen. English teacher for the win. Oh, man. It's a mistake. You know what she means. She feels injustice and wants her attorney to fight for her. It's not terrible. She's coining new phrases. She wants her attorney to be her champion and defender. Amicable, to obstruct or harm. Thank you, Vicinator. We'll add that to the dictionary if we can. But yeah, these complaints about her lawyer, it's gotten to the point where her lawyer said, I want off. I cannot do this, Judge. And she's listed a lot of things, reasons why. Let's see. Let's jump forward to see if we can sum up the rest of this. This does not mean my case can't equal success in more than one way. She knows her case is bizarre. She knows it's unknown and different. There's ignorance present. She thinks the ignorance is outside where she stands. Misunderstood and unfair. Those are all, I think those would be all finger pointing out feelings. But the first part, that top line, bizarre, unknown, and different, I think she's acknowledging that this is a weird case. This is a strange one where you have someone who passed away basically as a result of something that she did, but she thinks that because her situation is different, it's bizarre, it's not like the normal type murders cases that come up, that this ignorance and misunderstanding and unfair ideas about her are the cause. And what this basically says is that she will most likely want to testify in her own defense. She will want to take the stand and say everything. And by everything, I mean not intentional. I cannot see in any way, shape, or form Sarah Boone going to trial and sitting through all of it with whatever the lawyer decides to present as her defense and not speaking at the end. She is going to get up there and probably disparage her lawyer, disparage the court, disparage the process, the investigators, and then claim her innocence based on what she sees is this understanding that she knows her case is different than everybody else's because it was unintentional. And this doesn't mean that my case can't equal success, and in more ways, more than one way. So I can only assume that one of those ways would be her vindication, her freedom. I don't know what the other way would be. While everyone continues to ring their bells of benevolence, I am ringing mine of hope, honor, plausibility, boldness. Listen. Can you hear her bell? I'm not a murderer. The justice system should be fair. Faith, trust, respect, innocent till, and if adjudged otherwise, 3-point back, Sarah Boone. Confused cat meme. Yes, thank you. I think this part right here on the bottom, confused cat meme, this means something to someone who was written to Sarah Boone. There's something out there that this is a coded message, I think. This is is the walk the dog, says Greeners. What I'm going to need suggestions of which confused cat meme you think is she's referring to. And the yes, thank you. Somebody sent her something, a meme about a confused cat that probably in her mind perfectly encapsulates the case as it is so far for her. So I think it's the smudge cat. It's the lawyer. I'm not a cat. Grumpy cat. There are so many cat memes. I mean, it could be any or all of them really at this point. Interesting, but that I think is just and the love part. Okay, this is to somebody she likes. This is to someone she relates to in some way or feels a kinship to. Coach Karen, thank you. Love the cat. But there's somebody out there who's supporting her, and this is a response to that. But the 3-point back, that's not a basketball reference. That's referring to don't judge me, judge yourself, which is always good advice. She goes back into the video visit a little earlier. Thal, I'm going to hold off for a minute. I'm going to try to get through this letter. Maybe afterwards. Is that cool? Let's see. In addition to my previous intended for hand delivery on 6/7, my status hearing, today my attorney made a video visit. Okay, so she wrote this June 4th. In addition to my previous letter intended for... So she wrote her previous letter intending to hand deliver it on the 7th, but then 3 days prior to that, she got a surprise meeting with the attorney to go over everything I've been asking for. So she writes a letter to the judge that she wants to give to the judge. I'm not sure which pages it was, probably the one that ends with a confused cat meme. Then prior to her being able to give that to the judge, the attorney shows up and says, hey, let's go over everything and meet with you. And she's like, okay, so now I've got my letter pre-written, but now we've had another meeting. So this is addendum to the letter. Let's see, a status meeting today, made a video visit to go over everything I've been asking for, and have also sent to her personally in 2 letters. So there are 2 letters to the attorney. Those we do not see. That's attorney-client privilege. Those should never be made public unless Sarah Boone chooses to do so. All in the public video visitation box, which she does not like, where both sides of me less than 5 inches away from my visit. Other inmates were having their visits also. I explained to my attorney numerous times, both in writing and verbally, that despite the noise level, I do not in any way feel comfortable having in-depth private meetings. Okay, so noise level saying, oh, it's so loud, nobody can hear what you're saying. I agree with her. That is not a private meeting with people sitting on both sides. They could be acting like they're talking on the phone, but not be. We'll get some water. I need it. Okay, so I'm with her. I think that she should get some private visitation with her attorney that allows her to at least go over her case, important details of her case that should not be public. All right. You got 62 other interested people, all ears inmates. These other inmates, all ears inmates, get to read this as well. They're like the public. They can search other people's dockets, and I'm sure they do because they know their docket is public. They probably search Sarah Boone's docket as well. So they're going to read this letter and know that this is what she thinks of them. That probably is not a good idea, but it is what it is. I can't fully participate, if at all, from the entire dorm, officer included, trying to participate also in my case. It's a discussion with her attorney. There should be no recording going on between the two sides. The officer is supervising the thing. There's a lot of noise, but she still feels that she can't participate fully in her defense because of the non-private setting. As always, my attorneys did not listen or care. So apparently this is a theme that's continued beyond just this one attorney. Barking at me, I can listen or not. apparently this was a conversation to watch. Still going, over speaking, and not at all allowing me to respond. So this is a complete breakdown. What we have here is failure to communicate. Her attorney is not able, is basically yelling into the phone, listen, this is what you need to hear. And Sarah's saying, I don't want to do this out here. And they're just, and finally Sarah just hangs up. She wants to, after repeating to her over and over and over, while she's beginning to speak louder and over me. Okay, listen to this. After repeating to her over and over and over, while she's beginning to speak louder and over me, still to please schedule an in-person meeting where all can be discussed further privately with no success of being heard, I disconnected the visit telephonically. I slammed the phone receiver down on the hook, is what she's saying. And she disconnected uncooperatively. She had to leave. The conversation was over. She is impossible. See previous letter, or ask her for a copy of the 2 I sent her. That's not going to happen. There's no way that Attorney Cashman would give those to the judge, even though she says ask them. That is not enough for the judge to say she's given consent to violate the attorney-client privilege. That won't happen. So those 2 letters will remain private unless Sarah Boone herself releases a copy of them. Let's see. Who acts like that and is still able to call themselves professional? Now she's just attacking the judge, or the lawyer specifically. She doesn't like the visitation box because she thinks she has confidential information. Basically, attorney-client privilege information. And I agree that she should have the ability to communicate with her attorney that is outside the prying ears of whoever wants to listen in, whether it's the guard or the inmate in the booth next door. I think she has a, especially because the mechanism is in place to do that she has a valid complaint there. They blame their dysfunctions on me. You don't like the lawyers I give you. What answers? I'm not the problem except that I want to and should be treated fairly with respect, acting more professional than the paid. Okay, the paid is going to be, she thinks, acting more professional than the paid. I've been doing this for more than 40 years, professional. I should be treated fairly with respect, acting more professional than the paid professional. I think she got lost in that thought a little bit. After so long in all experience, common courtesy, customer service, and listening skills should have been acquired. She's like, you should, with all your years of experience, you should have learned by now to be polite. All attorneys, do you remember why you even wanted to be one? Kurt, do you remember why you even wanted to be an attorney? Matthew, can you answer this question? Remind yourself, she says. This is just an open letter to all attorneys. Goodman Law Firm. Nicole, just in time for this question. Sarah Boone wants to know, do you remember why you even wanted to be an attorney? And remind yourself. Good to see you, Nicole. Welcome back. So no one listens, and it works in everyone's favor but mine. Okay, this no one listens, this goes two ways. The communication is not something that you can just force down somebody else's throat. Nicole's like, yeah, I remember. That was the moment. Nicole, that's awesome. It's not. I'm not saying that was a wonderful experience, but that you took a very bad experience and said, I want to make a change. That is really cool, and it's great to have you here. Hope you're doing great. Let's see. Communication, two-way street, right? It only happens when one person talks and the other person listens, and then there is some role switch where the other person talks and the first person listens. I don't know how much listening has gone on with the lawyers, but I imagine that some of the talking that's gone on from the Sarah Boone side is probably more than the lawyer wanted to listen to. There's probably like a threshold that they met and said, okay, we're good there. Lawn lumber, why did you find this now? My brain is trying to figure out how to add something to the docket. Dang it. Rob, welcome. We have to go back. Why do you... Here, we're going back just for Rob. Where's my mouse? There it is. Sarah Boone has asked you a question, Rob. All attorneys, do you remember why you even wanted to be one? Remind yourself. In case you've forgotten. I assume she assumes that you've forgotten. 58 pages. This is long. Most of it is just law dictionary terms. I mean, she literally ran out of things to say to the judge of complaints. This letter is devoid of many of the complaints we've seen in all the previous letters, where she says, my lawyer won't answer my questions. He won't. Well, that part's still in there. They won't meet with me. They won't spend time with me. I'm sitting here wondering what's going on. In this case, her lawyer is meeting with her and is telling her what's going on, but she doesn't like the way it's happening or what she's telling her during those meetings. And so the complaint shifted a little bit, and she runs out of things to complain with after that. And that leaves her with this, that gets us 20 pages in of complaints, and now we have the remaining 38 pages, which she just fills with law term definitions, or in some cases just the law itself, where she just copy-pastes and puts it in the letter for the judge's benefit, I assume, because the judge likes good citations in emotion. This is not emotion though. This is not something the judge can look at and take action on. Now it's possible that in his next hearing, which will be with Attorney Cashman, there's got to be a hearing. He's got to hear that motion where she asked to withdraw, that he will consider or mention something that was in this letter, or ask a question of Attorney Cashman for clarification about something that's in this letter. But for the most part, this is not something the judge can sit in front of his desk, look at, take action on, rule on, and file away, and that was done. It's basically just extra work for the judge. That's no good. Okay, so she complains about the justice system a lot. She's confused that with public opinion and the media in general. This is interesting. I have not fired any attorneys appointed in my case. She wants to fire this one. She literally walked out of her last meeting with this lawyer and says she's impossible. So although she hasn't said those words, she's refusing to work with the attorney. Let's see. And represent myself is not an option, as both judges have. This is important. This has been brought up by, I think, at least 2, possibly 3 of her last attorneys have mentioned maybe she should just represent herself. Maybe Sarah Boone is the best lawyer for Sarah Boone because she knows how she wants it to go. And there's no better person than her, because I can't ethically. I can't do what she wants me to do, considering the oath that I have taken. Sarah Boone says, no, it's not an option, which means she's now stuck between this rock that she has placed herself on, on one side of this rock where she says, I will not tolerate anything other than treatment or representation that looks like XYZ. And she wants another lawyer to come in and match that. And the lawyers are looking at what she wants, whatever it is. It's not all it's provided to us, but whatever she wants, the lawyers are saying, we cannot do that. We have obligations to the the court itself, as an officer of the court, I cannot go forward with what you want me to do. Let's see. They're always saying, blame Boone. I refuse to be moved and want to respect, no matter who everyone thinks I am. Clarity, inclusion, honesty, and professionalism. I believe her lawyers probably began with respect. I have a hard time imagining that a lawyer walked in and said, sit down, shut up, I'm going to tell you how I'm going to represent you. I don't think that's how it began. I think what would be more accurate maybe was something more of like, hey, I'm so-and-so, representation, this is, you're charged with this, and she wants to talk, and they're like, well, we have to go over the basics first, and it just sort of deteriorated from there. But it got to the point where there was mutual disrespect, and at that point, it's rare to have one side say, you know what, you're right, I need to listen more. Lay it on me. They probably said, I don't have to put up with this. I've got a lot of other clients who will pay me more than you to sit here and take this sort of abuse. Okay. She doesn't want her visits public. I can see why she doesn't want that. She goes into some detail about her personal life. Apparently there's more details that are available if you contact the jail, and people have been doing, I believe, FOIA requests and getting some of that information. I have no interest in that. I'm more interested in the trial itself, the case itself, and her position and her interaction with her lawyers and the court, and that little bizarre love triangle, I guess we can call it. Whether or not she eats breakfast it means nothing to me. I haven't gone there, but apparently there's interest in there, and she's seen it in her life, which is sad, because I don't think that's relevant to the case at all. No one knowing anything. I take issue with this as well, because for the most part, Sarah Boone has the same access to information as I do regarding her case. She has a tablet, she has a computer, she has a television. I don't have a television, so she's got one better than me, right? But she has the internet, she's got a computer, she's able to, just like I am, using the same method I am, access her own records, the public records. As a matter of fact, as a party member, she can log in and get more than I can publicly of her case. But she seems to feel that everybody else finds out first about her case. And they do, because she's not constantly refreshing. I mean, 7 times today, I pulled up her docket to see what was new, to see if this letter had dropped. It was 10 days ago we heard about this letter. We wanted to see it. So I've been checking this religiously. When a lawyer files a motion, so like a motion to withdraw, if she's not personally there for that motion to be filed, she's going to hear about it from somebody else, most likely. And I think that's her big beef, is that other people know first. She's like, why do I have to find out from news that my lawyer wants to quit? Well, maybe if you talk to your lawyer and listened a little bit, she would tell you. Okay. Before my trial and before I've seen it, I don't think the public has any more information about her trial than she does, but they definitely are probably quicker on the draw and picking up new information. She cites some law here about restricting disclosure. I don't think that applies to anything that she's upset about. Don't knock it till you try it. 3-point back. Race to the pulpit. This race to the pulpit, I think, is a new strategy she's adopted, which we've seen, I think, beginning with her letters where she wrote it basically to all the world of true crime, to all those following her case, to the media, to people like me, where she addressed all of us and said, I'm just setting the record straight. This is her race to the pulpit. And in a way, she's both claiming that doing what we're doing now is poisoning the jury pool, but she also wants to get her side out, which she feels isn't being told. So I don't know how you can do both, get your side out and not poison the jury pool at the same time. She cites Florida rules of criminal procedure regarding discovery. I think she's not making a motion here, because the rules she lists here specifically state that if she has an attorney, the motion that she is referring to has to be filed by that attorney and signed by that attorney for all this to apply. Yet she's saying, I want all my stuff. Why aren't you giving it to me? The law says you're supposed to give it to me. No, your attorney can file a motion, and then this law kicks in. But right now you can't, unless you represent yourself. And if you choose to do that, trust me, the judge will not let you back to have a lawyer. Once you go pro se, there's no going back. And she's not going to do that. So she cites all this law, which really means nothing in her case right now. Because according to the state and according to even her attorneys, they have everything. All right. She's got parts in here that she's, starts putting stars by. Eventually everything will have a star by it as we get to the end of the letter. But she thinks there might have been some wiretapping, surveillance, phone tapping of conversations. The jail does record conversations that are not attorney-client privilege conversations. Those are out there. I believe they're available by FOIA request. Let's see, search and seizure of documents. She wants things back. I think she thinks there's more out there than there is. Let's see. She thinks police reports. She lists she cites parts of the law that definitely work against her as well, which is nice of her to cite for the rule of completion, so to include the entire law, including the part that says that we shouldn't do this. And then she cites the defense obligation of like her defendant's obligation to participate in discovery and return stuff that way. As far as witness list, she thinks she doesn't have her witness list. That part was a little strange to me because she knows she's pretty much got the prison break investigator. That's it. She doesn't really have. Other than that, it's basically people that she knows, people that are either neighbors, people that are family, past relationships, anyone local to that area. She has that list. All right, I think we're almost done. Restricted disclosure, sanctions. We've got the willful violation, pretrial conference. This page left intentionally blank. Individuals shall have full protection. This is where it gets fun. This is where she starts just citing like memorable pages that she's highlighted in the Boulder Law Dictionary, which is good stuff. I mean, she's halfway to passing the bar exam already. We've got the Declaration of Independence. We hold these truths to be self-evident. Also, from the preamble from the Florida Constitution is in here. And then we sort of delve into this long list of asterisk definitions, and for the most part, I think the definitions are fairly well copied from the dictionary. But some of them she got from like Merriam-Webster, when she should have got a dictionary that was a law-specific dictionary. So you have some meanings that clearly apply to voting. Okay, she used the voting definition as opposed to the legal definition, and so she probably could have done a wee bit better on the dictionary, but I think it's still worthy for publish. We should take those 30 pages and publish them. Let's see, duress, lots of definitions, and then she inserts this. This is a fun one. Not here. Let me scroll down. There's a point where she goes into hearsay. And that's sort of interesting because it's an exception to hearsay. There's a possibility that the pages got shuffled when the judge was reading this. So let me see if we can follow this. Let's see. It's Miranda. We've got the map. Love the map. And she's got an asterisk. Home sweet home right here. North Carolina. That's me. It's actually, she's got a star on Raleigh. That's not me. I think we're good. We're still flying under the radar. Then the world map, countries I'd like to visit. No, this is something else. Countries that have written me letters is what this one is. Let's see. That's where she's gotten email from. I need to see this. She talks about exploitation a lot, but she's basically feeding the same machine. Invasion of privacy, Supreme Court, wrongful conduct, invasion of privacy. This is almost like a threat, possibly to any institution that is publicizing information about her. And she has the premise that any information that's published about her is false because nobody understands her. Yet the majority of what I've seen out there is something either she has written or something that she has said, and it's a recording of her. So I don't understand why she would have that belief that everything that is out there is false and is incorrect, when it's just people taking what she has said and not believing or not interpreting the same way she said it. Florida doesn't have a star. Jury's not tainted there. Laura, that's funny. Okay, lots of underlined words here. Publicity, exploitation, and saturation. It's almost the whole thing is underlined. More definitions collected from the dictionary, the Smart Communications tablet. That basically means the internet, right? So she Googled some of the words. I think, let's see, duress. Duress was one. No, let's see. Oh, here it is. Coerce. To restrain, especially by law or authority. To repress, to compel or constrain to any action as to coerce someone to vote for a certain candidate. I think there might have been a more legal term that would work better, but we've got the taint definition, which I was nervous about reading initially, but she chose the definition that was appropriate for the live stream. And then right in the middle of this, I want to see the page numbering, then we'll be done here in just a minute. We've got 7, 8, 9, 10, 11, 12. Okay, so it was in order. So it goes in order, and it goes from evident, the definition of evident, to a discussion about excited utterance as an exception to hearsay rule, which is not part of the evident definition. But she talks about the hearsay rule, and then about halfway through, she deviates from that to a discussion about what happened in her case with the interrogators. Back to coercion. Form of blackmail. She talks about FOIA. And that's basically, I think this is where the pen ran out, or court began. So that's as far as we got. There's probably more pages to come. I don't think this letter is complete. There's more of the dictionary to copy. All right. With that, I think we've got somebody on the phone. Let's see who this is.
Call from.
That's me. Oh.
Hey, Thal. Thal, are you there?
Yeah, what's up, buddy?
Hey, we made it through 58 pages of Sarah Boone greatness.
Exactly. Well, listen. I just wanted to cite real quick, okay? Listen, chicken on roofs can't sell points to tomatoes per my slit on the dog in the oatmeal, okay? It makes total sense. I don't know how you people are missing this, all right?
It's a little bizarre. I will say parts of her letter resonate with me more and more every single time we get one. The fact, when she cites how long it's been, how long she's been in jail, that like hurts. That's like, this should not be, because consider yourself, accused of whatever, whether you did it or not, okay? 5 years waiting for your day in court. That is too long. 5 years is too long. It should not have got to that point. Now, her case is very different, but the thing that makes her case different is Sarah Boone. It's not that this is some weird law that no one else has been charged with before. Okay, we've been charging people with second-degree murder for decades. There's nothing new about that. We've been defending second-degree murder, defendants for decades. Florida's been doing it for a very long time. There's nothing new about those facts. It's more about her relationship with her attorney and problems they have there. And some of those.
Well, and the thing is that. The problem is too, what the courts would tell us is that, well, she has a right to a speedy trial, and anybody that complained to them, well, it's been 5 years, they'll say, hey, she needs a defense lawyer. If she can't keep one, that's not our fault. You know what I mean?
Oh, yes, but when she says, I haven't fired any of them, they've all quit, that holds water. They quit because they couldn't stand her. But she is talking. You have the right to have an attorney. Okay.
Right, but we don't have the right to make the lawyer suffer under a client they don't want or can't mentally handle. We're not allowed to abuse lawyers for a defense. We're not allowed to do that.
Who has the greater right there?
No, the
Somebody
defendant does. Well, if they have a lawyer that'll stick around.
Yeah, this is just crazy that I think her right to a lawyer supersedes the right to the lawyer to enjoy representing the client, right?
I don't.
The lawyer's right to life, liberty, and the pursuit of justice in their client's defense.
You know what I think it is?
Yeah, the client's right.
No, Scott, I'm on to you. I'm on to you, big boy. Okay, I know what it is. You just want to see defense lawyers cry. That's what it is.
There's nothing wrong with that. But no, I think she has a right. She's absolutely right. And maybe she's gaming this, and a judge will probably be able to make a call on this at one point, and it'll be subject to review by higher justices. But a judge might look at the situation and say, you know what? You're working the system. Your actions with your lawyer is forcing them to withdraw, to stall. Mm-hmm. And at that point, they will be able to say, you're going to self-represent. You've forfeited that right, just like Darrell Brooks forfeited his right to be present in the courtroom when he just would not shut up about subject matter jurisdiction.
I think the thing is, well, the reason I stick on the side of the lawyers to be able to say no, I don't want this client. The reason I stick on that is because of the old saying, your rights end at the end of the other person's nose. You know what I mean? So you can't. For your right to be exercised, you cannot inflict an injustice of a right on another person. You can't do that.
And
you know what I mean? Because they have rights too.
Arguably, there's some abuse of lawyer going on here.
Yeah,
but
we have a lady that I truly think is schizophrenic, and the problem with schizophrenics is I tend to feel sorry for them. The reason is because schizophrenics. Their filter on reality screwed up is the reason I feel bad for them, is because their filter screwed up. They can't tell. It's not that their brain can't process information correctly. They can. The problem is the filter, the information getting there is completely messed up.
I don't think she has any medical condition in that way. I think her intellectual processing abilities are different than most people. And it might be just a matter of perspective where she sees herself as in the right always, regardless of the situation. Yeah. So you've got her, oops, somebody died because I zipped a suitcase closed. Wasn't my fault. I didn't mean to do it. And in her head, I think that makes sense. I think she honestly either has convinced herself or believes that it wasn't her fault because she didn't mean to do it. And then anytime somebody doesn't believe that, she looks at that as them being disrespectful to her. You're not respecting my opinions because it was unintentional. And at that point, that's where the lawyer-client relationship just disintegrates and they separate. But
I think we should do. I think we should I think we should all write a letter to the judge, okay, and request that law and lumber and uncivil law take the case. Tell them that they really, really want to take her as a client.
I don't want them to shoot me. I don't think they want to do that. I'm not a big fan of writing letters to the judge unless you are personally involved in the case. Let me just put on the record. I'm not a fan of intervening at all in a case.
No, I was kidding. I was kidding.
I just need to put that out there. I've got you on the phone. Let me do a couple just shout outs for a couple people. Is that all right, Thal?
Yeah.
Mike W., member for 9 months. Oops.
Real quick for Lenova.
Yeah.
Sorry about this. Real quick for Lenova. No, I am not a lawyer.
Yeah. Thal, I've got another call coming in. Can I catch you in just a minute?
Absolutely. We'll talk later, brother.
Right,
we'll talk next week. Enjoy your party, bro.
Yeah,
Enjoy your party, all right?
Okay. Bye.
I'll see you, bud.
Call from
Joe.
Hey, this is Recovery Addict. Who's on the phone?
Oh, hi, Scott. This is Joe. I haven't called for a while.
Joe, welcome. It's been a while. How are you doing?
I just have a theory.
What's
and
up?
I don't know if anybody else has brought this up. So my first question is, what is the maximum that Sarah could get for second degree? Is it 10?
I thought it was life without parole.
Oh, you think it's in Florida?
In Florida, it's second degree murder. Florida, second degree. It's not manslaughter. They're going for murder. Murder 2. Max sentence. I think it's life without parole. Life in prison.
It is life. Okay.
I'm not sure if it's without parole, but life in prison is the max.
Okay.
It would, let's see, aggravating factors would make it a minimum sentence of 25 years. Like if they used a firearm, the law didn't. The law didn't comprehend that somebody would use a suitcase, and so that's not written in as an aggravating factor. Prior convictions. No
So
prior
for some
felonies.
reason,
Go ahead.
somewhere I thought I saw 10 to 15 years. I don't know where I saw that, but
Well, it's up to life. I'm not sure if the minimum sentence is 10 years with no prior felonies. And I don't think she has any prior felonies. I know that she has, through some domestic situations, she's been involved in the legal system before. And I'm, that's not this case. Well, in a way it is, because both of them were involved in the legal system with each other. But maybe that'll be brought in. It might be relevant. It might be too prejudicial. But I think the minimum that she could face is 10 years, which is crazy to think that that it's possible that she could be convicted and have less time to serve than she's already served, or be, in some cases, eligible for parole nearly immediately upon conviction based on time served.
So she's currently in the county jail, correct?
I think they're holding her actually in the prison. If you look at this, she's in. Let's see what her address says. Orange County Department of Corrections. But
okay, so that's not a prison.
Florida Department of Corrections is where her legal support correspondence goes. So state would be prison, county would be jail. I think she's in just for convenience. I think she's actually being held in the prison.
Oh, okay. So then my thought is out the window then, because I thought maybe she was stalling to stay in the county jail.
Yeah,
and not go to prison and then have time served.
I don't think so. I think she is making good use of her time during incarceration. Like she's studying, she's reading, she's writing a lot. I think she's active that front. I don't think she enjoys it in the slightest. This is not somebody who's like, prison's not too bad, 3 meals on a cot, it could be worse. I think she really hates it. That's why she's counting the days. That's why she's, writing the letters and complaining. She probably has found not many friends on the inside, and has more people on the outside that are interested in commiserating with her than on the inside. Right.
Well, she is the smartest person. What did she say in her interview? Smartest person in
she
class.
excels at everything she does.
Yes, excelled. That was it. Yes. Okay. But anyway, I just thought maybe she was, not comfortable, but okay with the county jail, and she was trying to stall and get what time she had in the county jail taken off of her maximum security.
I don't think she's trying to stall. First of all, she's a mom. She has a kid. She wants to be in the kid's life. I think she wants to get out as soon as she can.
Well, okay. Good luck.
Yep. Well, thank you. Thank you very much, Joe. It's good talking to you.
All right. Thank you.
We'll see you.
Enjoy your show.
Yep. Bye.
Bye.
All right, we've got a couple more messages I need to get out here quickly. So Mike W., member for 9 months. Thank you very much. Kimby, 12 months. Woohoo, love Recovery Addict. Thank you, Kimby. I appreciate that. Wouldn't be the same here without you. 12 months. Congratulations on the year. Silky Mom's here, member for 7 months, says she really does need her day in court. 100%. I agree. Todd Who That Clement, member for 6 months. Thanks for all you do. Watch out for the hurricanes. Let's see. Michelle Phillips in North Carolina, member for 12 months, says, yay, thanks again. Red pen. Shells says, I can't wait to listen. Shells, I hope you enjoyed it. I hope I did it justice. Some of the handwriting was a little difficult for me. Just a Girl Baking gifted 5 memberships. Thank you very much. Lenovo gifted 10 memberships, followed by maybe another 10, or maybe this was just a double. Sometimes it looks like another 10 on my side. Either way, 10 memberships. Thank you very much, Lenovo. Vicky Mack gifted 5 memberships. Thank you, Vicky. Angela LD, member for 5 months, says, Karen's trial wrapping up soon. I can spend more time here again. Selena K gifted a membership. Thank you. Samantha Terry, one of our great mods, gifted a membership, 10 memberships. Mary M, member for 16 months, says, Red Pen, thank you so much for your gift. Much appreciated during my hard times. Mary M, thank you. And Red Pen, thank you for your generosity. It's wonderful to have you. 16 months, Mary. It's been wonderful. Greeners said, did we figure out the meaning of cryptic 3-point back? We did. That's basically look at yourself. Look in the mirror. Who you call an ugly punk is basically what that comes across as. Cachette says, now again with feeling. I cannot read all 50 pages again. My voice would not hold out. Fletcher Boy says, Sarah is trending in Botswana. Oh, man. Yes. There is an international following for this case. It's remarkable. K-Rab says the complaint about her not being included in hearings was several lawyers ago. She's been included in every hearing since. I think there was one after that she was not. But I think it was a motion to withdraw, if I remember correctly. I'd have to look at it. Stan Advocate, member for 7 months, best channel on true crime on CrimeTube. Thank you very much, Stan Advocate. Thanks for 7 months of support. Josh Hutchings also gifted a membership. We appreciate you, Josh. Let's see if we have some questions we can answer in chat as we get back to that. How close are you to 57,000? I can look. We're right here. It goes up and it goes back down. So we're at 56,909. I think we're down 27. I hate to say it, but we lost 20 during the podcast. Maybe this means Ashley says that's kind of funny. Maybe it means we need the podcast on its own channel so it can grow without the hindrance of LawTube. But anyway, it's a lot of fun. It's the dad jokes. It probably is. Ask your family to subscribe. We're so close. It'll happen when it happens. Honestly, oh look, it's going up right now. Thank you all. Whoever. Wow, we've had amazing growth just in the last few minutes. When we're covering live trials, it's obviously much more interest. I know that's what you guys want, and we will be back to live trials here soon. There's many things happening. We've got Corey Richens is in a hearing today. We're going to watch for the updates on that, and if we get a court date from there, I cannot wait for that one. Might actually travel to be there in person, which because I'm already on the media pool for that. Alec Baldwin's trial had a hearing today, trying to get his his armor to testify against him. That was spicy. We might cover that next week if we have some downtime. We've got that coming up. We've got a few other things. We've got Black Swan coming up. We've got some good ones, and we'll be covering all those live. So, or maybe not all of them at the same time because some of them overlap. Okay, she gets a confused cat tattoo. We really know it's code. I stop the podcast, do the like, and then leave normally like everybody else. Hedgehog in Space says, do you know what happened in the found daughter estate case out of Judge Wolf's courtroom? Hedgehog in Space, I wish I had this answer for you. I have not been able to find it anywhere. I think this may have been resolved amicably outside of the judge, so it didn't require a ruling, and they just closed it out. I wish we knew. I want to know if this was a long-lost daughter that is entitled to the estate, or if this is some charlatan who came in as a fraud and saw opportunity. And I think we'll never have that closure. It's like the JFK assassination. We'll just have to guess from right now what really happened. Let's see. Sorry, I didn't expect you to read that. Oh, it's all right. It was a lot getting through that letter. The handwriting, it grows on you. And I've become a little better at reading her handwriting over time because she definitely has, like her M's are very distinctive. They look like U's or N's or something. Thank you for answering. Thanks for asking, Hedgehog in Space. I appreciate that. Remember that poor lady's case? Yes. When she signed the letter, she added confused cat meme. I need to see. I'm going to start Googling. I'll probably be stuck on the internet all night looking at confused cat memes, just trying to guess which one is right. But I think she is speaking to somebody who wrote her a letter. She has mentioned she has a fan club that people write her letters of support. And some, I think she even mentioned that some are trying to support her financially in her efforts. We'll see. I don't know if that was just a rumor or not. She thinks in cursive and writes in cursive. Let's see. If you saw me 20 years ago, Thal, you'd fall over 98 pounds and 4% body fat. That's a slight gust of wind, and you could be carried away. I don't think she's schizophrenic. I don't think she has a medical condition that's diagnosed like that, of that nature. I don't think she has a medical. Is it wrong to say defect? I don't think that's the case. I think it's just her ability to reason and logic gives extra weight to her argument and lessens the arguments of anyone else in her mind. That's what I think happens. If that's a condition of some sort, maybe it's that. Her fans were supporting her bail fund. If she wants a bond, I don't think that'll happen. But arguably, that might be the best thing to do at this point. I mean, she's been in for 5 years. Give her a bond. Why not, right? Let's see. I think I know which one it is. Should we text your burner phone, cat phone memes? Sure. Go ahead. We'll go ahead and do that. She can read Latin, but can she read Korean? Do not know. She's making use of her time and studying. Let's see. Histrionic personality, possible persecutory delusions, narcissism. Narcissism rings true a little bit, Kaylee. I'm not as familiar with the other possibilities, but you probably have a little more experience in that realm than I do. How many membership months for the yellow courthouse? That would be at 6 months. 6 months is yellow, orange is 12. Did he mean medical diagnosis? Yes, that's probably a better term. I knew it started with a D, and I got the wrong one. Defect was definitely the wrong term. I apologize for using that. I have a mental defect that makes me not be able to think of the right words. It's a confused cat watching the video of him in the suitcase on the TV. Anyway, here's what I expect going forward in the Sarah Boone case. Let me first pull it up one more time and see if there's any new filings or scheduling on her case, because that's the next step. I think we're going to have the judge scheduling a hearing to hear the motion to withdraw, and it's not out there yet. We still just have the pretrial management conference on 9/24, and then 10/7 we're slated for trial. So before, I would say, I would be surprised if it's much later than say early July. We're going to have the hearing on the motion to withdraw. Sarah might not be there. Sarah Boone might not be there. I don't know. We'll see. But that's definitely going to be covered. The news media is picking up on this as she gets progressively more and more lawyers under her belt. That's bad. No, notched on her wall. I don't know what you want to do with that. As she has more lawyers, it becomes more of a story in and of itself, just the number of lawyers. So we'll see what happens here. The judge in the past, the previous judge, when it was under Judge Wooten, I think, wasn't it Wooten, was reticent to release someone and really probed at their reasons for why they wanted to be released and fought against it, at least on 2 occasions. This is a new judge. I'm not sure. He's expressed an interest in moving forward. He's mindful of how long she's been in custody and probably feels pressure to let her have her day in court as well. So I don't think he's going to be a pushover when it comes to getting her off the case. We might have a situation where he looks at it and says, look, you've gotten further than any other lawyer with Sarah Boone. Can you just stick this one out? But we'll see. Anyway, so that's what we're going to watch for is the new hearing, and I'm sure that's going to be televised, even if it will be just briefly, 10 minutes in court. I'm so curious. It's a cat confused watching the boob tube of him in the suitcase. I'll watch for the burner phone and see what the meme looks like. But on that note, I think we are done for tonight. We have the weekend before us. It's Friday evening, 7 o'clock. I think we have some great content on LawTube. Lawn Lumber, I think, is going to do his Friday Night Frenzy, which is always entertaining. Some amazing things have happened, but not just in Sarah Boone's case. The Young Thug trial has been just, one gift after another for those that just like watching comedy or circus behavior in court. That just never ends. Any day now we might have motion on that one from the Supreme Court, possibly putting a hold on the proceedings as they decide what to do. I think they have to take action. We talked about that previously on the surprise stream last night. So we've got that. We've got, obviously, all the developments in Karen Reed trial. We finally have the evidence we've been waiting for through all the trial. And honestly, my take on it is it's pretty good for the state. It's pretty good. The people that have been giving the evidence, for the most part, have been not the best, sometimes a little bit boring, or maybe not the highest credentialed. But when you look at the physical, the hard evidence, the extraction of the data, they've got some good points. They've got some good stuff. Is your uncle on tonight as well? 8 Central tonight? That's going to be awesome. So you've got your choice of absolutely amazing lawyers and content creators to choose between. So Young Thug, Karen Reed, obviously Sarah Boone has now developed. We've got a lot that's happening just today alone with Alec Baldwin in the Rust shooting trial is going down. We have coming up, not far in the future, we have the Treehouse murder trial, the retrial, because that one ended in mistrial initially. That's coming up. Yeah, what more could you want, right? Yeah, it's like a cornucopia of choices out there, which is great. RA not checking my text is giving me a complex. Adam, Google me Nusky. Oh, let's see. Adam, where are you at? Let's see. Hedgehog in space, I got yours. That's great. Nova, I see the cat meme. You're all sending the same cat meme. Sarah Boone letters ready. Adam, where's your text? Oh, here it is. Got a lot of letters. Adam, you've sent me a bunch of stuff that says file type not supported. So I don't know. Lenova, thank you for the super sticker. Everyone, it's been a wonderful day. It is Friday. The weekend is upon us. We've got obviously some great stuff to watch and listen to and participate with tonight. Do go somewhere. Find a great content creator, watch them, support them, give them a thumbs up, maybe a super chat. That would be amazing. Other than that, tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again. I expect Monday morning between 8:30, 8:45-ish as we have more Sarah Boone. We expect the state to rest next week because we don't know what happened today. Don't spoil it. Okay, so we expect them to rest next week. Until then, I have a party tomorrow. I haven't been to a party like a boys' night out party in so long. I won't know what to do. Do you bring cake? I don't know. Anyway, you guys be good to each other. See you. Have a great weekend. Bye.
I'd agree that everything you just said is one of the most horrible things I've ever heard.